Hello everyone, my name is Vaishnavi Parate. I am a law student and today we are going to discuss and learn about what is the doctrine of double jeopardy. Let's start with the introduction. The doctrine of double jeopardy is a legal defense that protects an accused or defendant from being tried again for the same accusations and facts after a lawful acquittal or conviction. Double jeopardy is a doctrine from the Indian Constitution, specifically Article 20, Clause 2, which deals with and specifies the meaning of the double jeopardy doctrine. It has been incorporated as a part of our basic right by the founders of the Indian Constitution under Part 3. Now let's see the meaning of double jeopardy. The doctrine of double jeopardy is a rule that states that no one should be put twice in peril for the same offense. No individual shall be arrested and punished for the same offense more than once. The Indian Constitution said in Article 20, Subclause 2. The doctrine existed in India prior to the Constitution of India as evidenced by the General Clauses Act of 1897, Sections 26 and 300 of the Criminal Procedure Code of 1973. Now let's see the grounds on which this double jeopardy doctrine applies. In three situations, double jeopardy is stated as a valid defense. First and foremost, the individual must be charged with a crime. In the General Clauses Act of 1897, the term offense is defined. Any act or omission that is criminal under the law in force at the time. Before a court or a judicial tribunal, the investigation or proceeding must have occurred. In the prior process, the person must have been arrested and punished. The offense must be the same as the one for which he was previously convicted and sentenced. Now let's see the origin of this doctrine of double jeopardy. The word double jeopardy comes from the English common law rule nemo bis punitur pro eodem delicto, which means no one should be punished twice for the same offense. The word double jeopardy comes from the common law rule nemo tibet bis vexar, which means a man must not be put in peril twice for the same offense. In simple terms, it implies penalty twice or punishment given more than once for the same offense. Let's turn towards the judicial perspective of this doctrine. The judgments make it clear that an investigation is not the same as a prosecution. This was asserted in the case of Venkatraman versus Union of India 1954, where the accused was subjected to an investigation by the Inquiry Commission after being fired from his job. Following his discharge, he was accused of violating the Indian Penal Code 1860 and the Prevention of Corruption Act 1988. He argued double jeopardy, but the Supreme Court decided that the investigation conducted by the Inquiry Commissioner to end his employment was not prosecution and therefore the charges may be brought and the defense of double jeopardy was dismissed.